Welcome to Monday Night Law here at Kirk's Law Corner. Is this August 17th, 2026? Just a cruising on by, aren't we? Summer's coming to an end. I'm live on YouTube. How's everybody doing out there? It's kind of warm here. Cloudy. Been doing a little bit of thunderstorming and kind of spot raining, but that's part of the reason why we're not going to go camping, is because thunderstorms and rain is what is predicted in the mountains. So calling off the camping trip this week. We'll probably go next week. So Wednesday night workshop will be on this Wednesday night. So let's see who we got over here. Telegram, Wendy, thank you for being here. Paint Gun Spooty, Kathy Watson, good to see you, dear. Diesel D is good to see you, brother. Wendy, thank you for running out there and checking audio for me. Karen, good to see you out there on Rumble. You're the only one that's there right now, although it says there's 8 people watching. Anybody else out there on Rumble? Mark? Jax? Amunzen 58? All caps, false prophet? Well, I didn't know if I was actually going to do it tonight. If we were actually going to go camping tomorrow, I probably wouldn't be doing this tonight. I'd be packing up to go camping, so there's that. But JPC5, good to see you. You're still there, Karen? Go. Good to see you. Rosalind, good to see you out there on Facebook. No, Rosalind, I am not a member of the bar anywhere. Would never join that club. Way better. I'm in Idaho, by the way. Well, looks like it's just you tonight, Karen. There's some other people there. There's nobody saying hi yet. Hey, James, good to see you. CC, good to see you. Yep, I shaved it all off. Got pretty scruffy. You know, that's the thing, Rosalind, the people out here, you know, we need to learn how to effectively defend ourselves. These members of the bar, they're not there to help us. As much as we would like to think that they are. We are being deceived. They're all about, let's make a deal, and you're screwed. It's just, how hard do they want to screw you? How much can they get you for? That's the reality of the bar, right? There's a couple of good ones out there every once in a while, but for the most part, they don't go against themselves. They won't go against law enforcement. They won't go against the government. Plain and simple. So last week we were talking about what is a constitution and that kind of stuff, and I was laying that stuff out as a precursor because the Constitution, in our federal Constitution, says it's the supreme law of the land. And law of the land literally is synonymous with due process of law. So it goes all the way back to, Magna Carta 1215, where it talks about that we cannot be deprived of our rights without the law of the land. Well, they changed it by due process of law. One, in order to deceive us, right? And the thing is that's not the process. The process is supposed to come from the common law process, because that's the law of the land. And so many people don't quite comprehend that, or just flat out just don't know, right? So when we look at, let's take a look at that here. Look at it. When we look at this as the law of the land, this Constitution and the laws of the United States which shall be made in pursuance thereof. So that means Article 5 Convention is made pursuant to this Constitution. And all treaties made which shall be made under the authority of the United States shall be the supreme law of the land. The statutes are not supreme law of the land. Those are enactments. Those are policy. So when we're talking about the Fifth Amendment, see, they always want to talk about the 14th. I always want us to look at the 14th. See? Nor shall any state deprive any person of life, liberty, or property without due process of law. So, are we talking about the 14th Amendment due process of law, which is the Roman civil law, the code? Because that's what the 14th Amendment does. This is implementing the code, the Roman civil law. But when we look at the Fifth Amendment, or Article the 5th of the Bill of Rights, it says no person shall be held to answer for capital otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval force or in the militia when in actual service in time of war or public danger. Right? Nor shall be compelled in a criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. So, they keep saying that, well, the Bill of Rights doesn't apply to the states except for by and through the 14th Amendment. No. Because, again, if we actually look at, like even the 9th, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. It is enumerated. I just read it to you in the Fifth Amendment. Okay? So, What Constitution are they talking about in the 9th Amendment here? And the same thing with the 10th. The power is not delegated to the United States by the Constitution. What Constitution? Nor prohibited by it to the states or reserved to the states respectively or to the people. So, funny out there, James, on YouTube. I can spiel better than the bar. That's right, they got that college degree. So, you know, when they go to ask me, well, are you talking about your right to due process of law in accordance with the 14th Amendment? No, in accordance with the common law or the 5th Amendment. Because remember, like I've showed you before, American Jurisprudence, Volume 16, Constitutional Law, Section 100, the Bills of Rights and those merely declaratory of the common law, this particular Bill of Rights is in fact just merely declaratory of the common law. All of these rights, Hale versus Hingle, our rights are long antecedent to the formation of the state. They pre-exist. But see, this again, they're trying to deceive us. But, you know, talk about in the Idaho Constitution, look at the verbiage here, how they rearrange the words there from the 5th Amendment, right? In all criminal prosecution, the party accused shall have the right to speed in public trial and have process of the court to compel the attendance of witness to appear in person. Oh, wait. In order to be deprived of life, liberty, or property without due process of law. It's not the one I'm looking for. I'm looking for the indictment. Where was it? Oh, right here. Section 8. This is Idaho, Article 1. No person shall be held to answer for a felony or criminal offense of any grade unless on presentment or indictment of a grand jury or on information of the public prosecutor after a commitment by a magistrate, except in cases of impeachment, in cases caused by the probate courts or by justice of the peace, and in cases arising in the militia when in actual service at time of war or public danger. Okay? But what else does it say there? Check this out. That a grand jury may be summoned upon the order of the district court in the manner provided by law, and provided further that after a charge has been ignored by a grand jury, no person shall be held to answer or for trial thereof upon information of public prosecutor. So even if they're saying we can do prosecutions by information, yeah, if it has to do with being in the military. I mean, think about this. Let's read this real slow. No person shall be held to answer for any felony or criminal offense of any grade unless on presentment or indictment of a grand jury. But then they say, or on information of the public prosecutor. And then it says, after a commitment by a magistrate. Now, let's look at right ahead, KU. We go into Title 19, that criminal procedure. Notice it said, after a commitment by a magistrate. Okay? It should be right here. Complaint and warrant of arrest. Person lodging complaint, 19-504. When a complaint, which has been subscribed to under oath by the party or parties lodging the same, is laid before a magistrate alleging facts constituting the commission of a public offense, triable within the county, and the magistrate finds that if the complaint alleges a public offense under the Idaho Code or county or city ordinance, the magistrate shall order the clerk of the court to file the complaint and refer the complaint to the appropriate county or city prosecuting attorney for further action. So it's not the city or county prosecutor who lays the complaint before the magistrate. Does everybody see that? Right? Let's go back and read this part again. After a commitment by a magistrate. But it's still supposed to go to a grand jury. Because that's due process of law in accordance with the common law. So, why are we not following? Why are we not following the law here? Right. But see, here's the thing. There's two different things here, unless on presentment or indictment of a grand jury. Now see, when we look at we have to comprehend this with the powers retained by the people. What does it say about that? Whoops. About all political powers inherent in the people. All of it. So that means the state legislature, executive, judicial, whatever, they don't have any powers unless we delegate that to them by and through the Constitution. That's why I covered that last week, was because this is going to, tie into last week's lessons about what a Constitution is. Hi, Michelle, Jeremy. Good to see you guys. So, here's the thing. If all the power is inherent in the people, how do they get any power? Well, we've got broad, sweeping, plenary power. No, you do not. You only have the powers that we delegate, because all of the power is inherent in the people, which means the people are the sovereign. Yeah, that's right. We're the sovereign. We're the masters. You're the servants, public servants, elected officials or appointed or employed, which we require you to be bound by oath or affirmation to support this Constitution. So, plain and simple, you don't have any powers unless we delegate them to you. Declaration of Independence. Receiving their just powers from the consent of the governed. The Constitution is how those powers are granted and how the people choose to be governed. But look at the next part. When we go down here about the right of assembly. Now this is going to tie into that presentment and indictment. The people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives. What this is actually talking about is doing those grand juries, assembling the people, because again, we don't need their permission. We retain this power. So we have every right to assemble the people, the consult for our common good. That's what that's actually referring to, is the grand jury presentment. And then we instruct our public servants to prosecute that presentment. Now, the indictment process, that goes through the court. The complaint's laid before the court. The court says, yep, assemble the grand jury, and they return with a grand jury indictment. The presentment, okay, let's see, and it was talking about the juries. Where was it? Of the several modes of indictment, I think. A presentment, here we go. Generally taken is a very comprehensive term, including not only presentments properly so called, but also inquisitions of office and indictments by a grand jury. A presentment, properly speaking, is the notice taken by a grand jury of any offense from their own knowledge or observation, without any bill of indictment laid before them at the suit of the king. As the presentment of a nuisance, a libel, and the like, upon which the office of the court must afterwards frame an indictment before the party presented as the author can be put to answer it. An inquisition of office is the act of a jury, summoned by the proper officer to inquire matters relating to the crown upon evidence laid before them. Some of these are in themselves convictions, and cannot afterwards be traversed or denied, and therefore the inquest or jury ought to hear all that can be alleged on both sides. Of this nature are all inquisitions of of flight in persons accused of felony, of dissidence and the like, and presentments of petty offenses in the sheriff's court, whereupon the presiding officer may set a fine. Other inquisitions may be afterwards traversed and examined, as particularly the coroner's inquisition of the death of a man, when it finds anyone guilty of homicide. For in such cases, the offender so presented must be arraigned upon this inquisition, and may dispute the truth of it, which brings it to a kind of indictment. The most usual and effectual means of prosecution, and into which we will therefore inquire a little more minutely. Then it goes into the indictment. Is a written accusation of one or more persons of a crime or misdemeanor preferred to and presented upon oath by a grand jury. To this end, the sheriff of every county is bound to return to every session of the peace and every commission of oyer and terminer, crimes basically, and of general jail delivery, 24 good and lawful men of the county, some out of every 100, to inquire, present, do, and execute all those things which on the part of our Lord the King shall then and there be commanded them. They ought to be freeholders, but to what amount is uncertain, which seems to be causis omissus, and as proper to be supplied by the legislature as the qualifications of the petit jury. So grand jury is 24, but it's a minimum of 12 for an indictment. The same thing with the presentment. Yeah, right, Karen? F equals S. And wow, you're the only one I'm seeing comments out here tonight. No, there's no Mark, Jax, or anybody. You're the only one that I'm seeing comments out here on Rumble, Karen. Freedom Fighter, good to see you. Wow, Wendy, hang in there, man. Good thing that you're okay, but everybody around you is not. Getting flooded out there. I wonder if Jax is okay. What about Tam? But anywho's, so that is the difference between a presentment and indictment. This is based on our own information, right? See? Is the notice taken by a grand jury of any offense from their own knowledge or observation, also known as their own information. So, this is where they're stealing that prosecution by information. That's right. It's a presentment. A grand jury presentment based on our own information. And they've stolen that power from the people, thinking that they can do that. Well, even according to the Idaho Code, they can't. They're not a party. Plain and simple. They can't be a party. They can't be the party and then it's sent over to them. Yeah, that violates due process of law. Plain and simple. That is not the process that is due. Right, James? Since then, I've actually discovered in the Idaho Code where it says that they don't have any authority on that side of the bar. Only on the other side they can control. So, yeah, I wish I would have known that then and had that particular Idaho Code and shut it all down right then and there. As it was, I stood up to the Idaho police to begin with, and they just pushed me out of the way. But, yeah. But so, this, this is the knowledge that's power, right? Once we learn what the process is, that process that is due, as in due process of law, is supposed to come from the law of the land, not from the statutes. And that's why, like in the State versus Clark case that I've covered a couple of times now, but very thoroughly here just a few weeks ago, about the Fourth Amendment, State versus Clark, and making an arrest without a warrant. That's the thing. The Fourth Amendment requires a warrant to make an arrest. The exception to that rule of law is for felonies or breaches of the peace. Plain and simple. So they sure are making an awful lot of unlawful arrests out there. They're depriving the people of their liberty and their property without due process of law. Article 1, Section 17 of Idaho is the reciprocal of the Fourth. And see, they always try to say it's the right of the citizen, the right of the citizen. They keep wanting his name to say that we're the citizens. Okay. So the question is here, Karen out here on Rumble, when do the people use code versus real law? The people should always use the real law, the common law. And this is the common law, the law that is common to all, the laws of nature. Okay? It should be the number one thing. But in situations where, like I'm talking about here, it's like, well, to clarify what it says in the Idaho Constitution, right here, your own code says that the complaint has to be laid by the party, the injured party or parties. It's not the city or county prosecutor, and it sure to hell isn't a policy officer. It has to be the injured party. Because who's going to swear under oath that they were harmed? Okay? The corpus delicti, mens rea, actus reus, all of those elements of a crime. And then, again, it has to be done through a grand jury. Got to go through a grand jury indictment. All criminal prosecutions of any grade. But that's the Fifth Amendment. And it's also the same way in the Criminal Practice Act of 1864. It says all crimes are prosecuted by the grand jury. That's the right to a trial by jury. The trial by jury starts with the grand jury and ends with a petite jury. That is the complete trial from beginning to end. It doesn't start with the information, and the trial by jury isn't just in the end there where you have the actual jury, the petite jury of 12 for the trial. So, again, we've been lied to, we've been deceived. Even the members of the bar, they've been taught wrong. So, yeah, Bill of Rights versus Declaration of Rights. This is key. Great question. Because I'll quote from Alexander Hamilton in the Federalist Papers, I believe it's Federalist 82, that he argued against the Bill of Rights because Bills of Rights are for kings, for monarchs. And, well, we're not a monarchy here, and we don't have any kings. We don't have rulers. We have servants, as he says. And it's already the law. We don't need a Bill of Rights. We go by the common law. But so that was part of the trickery, right? Alexander Hamilton was a double agent. He was a plant to subvert all of this. He's also the one that ushered in the International Bank. But anyways, the thing is he was arguing against the Bill of Rights because it would set that stuff in stone. But here they are today saying, well, it doesn't apply to the states except for buying through. Well, where in the hell would it apply then? Huh. I mean, it's a bill of rights. Rights as the law. Now, they're saying here that these are amendment. When we go and look and read the real Bill of Rights, it says at the top that these are articles in addition to an amendment to the Constitution of the United States of America. The entire Bill of Rights is the amendment, but these are articles in addition to the Constitution. And that's why the 9th and the 10th specifically mention this Constitution. Okay, so yeah, to clarify on the Declaration of Rights, we the people declare the law. Declare, mean lay down. Law is that which is laid down, ordained, or established. So that's why it's a Declaration of Rights versus a Bill of Rights in our state constitutions. D means down. Declaration, declaration, clarify, in writing. So we write it down. Okay? This is what a declaration does. It writes down the law. If we convert the word rights here into the word law, which is synonymous with law, comes from the French word droit, meaning right or law. So we would say Declaration of Rights and translate that into laying down the law. There's Mark. Good to see you, Mark. So this is what we have to comprehend here again, is the rights is in fact the law. It's the common law. Unless we're talking about that life, liberty, and property, those rights are from the law of nature. Okay? Those are primary, absolute, unalienable rights. You cannot take those rights and hold them for some debt. Nope. So, yep. So, hopefully people are catching on to what I'm laying down here. Trying to lay this out so that we all know how to defend ourselves from this crap. This process that is due has to be followed. And see, it's set in stone in the Fifth Amendment. But even here, when you go to the Criminal Practice Act of 1864, the real statute, and it says it has to be prosecuted by indictment. Doesn't mention anything about prosecution by information. I mean, it kind of does in the Criminal Practice Act. It does give an exception there in a different section. Okay, but it goes back to the same thing as what the Fifth Amendment says. But notice even in the code where it says under oath by the party. Now, when we go back to the Constitution and our Declaration of Rights, where was that? Was it in there? I keep forgetting where this, come on, particular section is. Remember if it's under the judicial. That I do want to point out, like here, power and authority over intoxicating liquors. Okay, see that how that's a subject matter jurisdiction being delegated over intoxicating liquors? Where's the one for cannabis? It's not there, is it? So there's no delegation of power, no subject matter jurisdiction. I think it's got to be in this one then. I wonder where it says prosecution. Da 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 da. Jurisdiction of the district court. See, the district court shall have original jurisdiction in all cases, both at law and in equity, and such appellate jurisdictions may be conferred by law. So they only have common law jurisdiction. Where in the heck was it? Maybe it was that one. Okay, there it is. Section 1, the forms of action abolished. The distinctions between actions at law and suits in equity, and the forms of all such actions and suits are hereby prohibited. We can't do that. You can't abolish the common law. But look what it says. And there shall be in this state but one form of action for the enforcement and protection of private rights or the redress of private wrongs, which shall be denominated a civil action. No. And every action prosecuted by the people of the state as a party. Uh-oh. Uh-oh. It's got to be one of the people as a party that lays the complaint before the magistrate. So, and again, the injured party. Happy belated birthday there, Mark. But now that you know this is in Idaho, but it doesn't matter. We all need to know this, but there it is in the Idaho Constitution. And just the fact that in the Idaho Code, then it goes over after a commitment by the magistrate, then it's supposed to be filed with the court clerk to file the complaint and refer the complaint to the appropriate county or city prosecuting attorney for further action. How was it that the county and city prosecutors are the one that's making the complaint? Uh-oh. So, and see, then again, going back to the Criminal Practice Act of 1864, it really clears things up, let me tell you. But that's the history, right? The history of this particular section of the code is supposed to come from the Criminal Practice Act of 1864. And then notice that it says RS as in revised statutes. Statutes cannot be revised. Statutes can only be amended. And then when we're talking about the Criminal Practice Act of 1864, oh no, that's set in stone because that's the common law process. And it was supposed to, well, it was done. In fact, the Criminal Practice Act of 1864 was the second thing that was ever created by the temporary legislature in Idaho. The first thing was the Civil Practice Act. So, how are we sitting here saying that we're not following that no more? Well, because it's all code, Roman civil law. Well, there's a comment out here on that'd be YouTube. Joe Moore. Idaho and state of Idaho are synonyms in meaning. Have the same lawful definition? No. Technically speaking, no, they do not. The state of Idaho, capital S, lowercase, capital O, and then capital S for, or capital I for Idaho, is how it's properly written as the name of a corporation. State of Idaho in all capital letters is a fiction. Doesn't actually exist. That's not proper English. We don't write in all capital letters except for, right? Here's your sign. It's sign language, which cannot be imported into any language. It's only supposed to be on the signs. Or like in the headings of a book, chapters, that kind of stuff. Here's your sign. But technically speaking, even then, it shouldn't even be written in all capital letters because that's not proper English. And then, here, look at this. Notice that state is a lowercase s in the Idaho Constitution. because that's the people. That goes back to the law of nations, right? What is a state? It is composed of the people, a state of being. Right? Yeah, Karen, I know. Sign language, as in there's the sign on the side of the road, or here's your sign on the face of the book, face of the page. And you're right, James, it's called gloss. It's a cursed corruption of the text. There's a maximum law on that. But, yeah, Mark, all capital letters state is not proper English and doesn't exist. The uppercase S state should be the Idaho state, as in government, which is still of the people, by the people, for the people. And then the lowercase s state is actually the people themselves, a state of being free. Tammy Tansy out on YouTube. Again, we need to learn the common law, because everything is supposed to be done pursuant to the rules of the common law. Seventh Amendment cannot be otherwise re-examined in any court except for pursuant to the rules of the common law. Another one is the Northwest Ordinance, 1787, the very first thing that they created that shows our true Republican form of government. Shall be appointed a court to consist of 3 judges, any 2 of whom to form a court, who shall have a common law jurisdiction. The inhabitants of the said territory shall always be entitled to the benefits of writ of habeas corpus and of the trial by jury of a proportionate representation of the people in the legislature and of judicial proceedings according to the what? Course of the common law. And no man shall be deprived of his liberty or property, but by the judgment of his peers or the law of the land. Due process of law, law of the land. Synonymous. But what is the law of the land? The law of the land is the Constitution. So, that's it. We need to follow the law of the land. I could care less what any statute says. Good to see you, Jacqueline. Glad you made it. So this is what we need to bring forth. Right? So, yeah. Oh, BS, Joe. There's no lawful money in existence. You can't have common law without lawful money. BS. Common law is law. I could care less about money. This has nothing to do with money. This is fundamental law. So pay attention and learn something. So the common law is what we're supposed to be going by. And even, like I've showed in the State versus Clark case, what did they go back to? About making an arrest without a warrant. They went right here. Number one source. The same thing with the Supreme Court of the United States of America. Number one source they get their go-to is this Blackstone's commentaries on the laws of England. And they cite Book 4, Section 289. Right? Here. Arrest by officers without warrant may be executed by a justice of the peace who may himself apprehend or cause to be apprehended by word only any person committing a felony or breach of the peace in his presence. That's what they cited right there. The constable, right, whose office we formerly spoke, hath great original inherent authority with regard to arrest. He may, without warrant, arrest anyone for a breach of the peace and carry him before a justice of the peace. And in case of felony actually committed or a dangerous wounding whereby felony is like to ensue, he may, upon probable suspicion, arrest the felon. And for that purpose is authorized, as upon justice warrant, to break open doors and even to kill the felon if he cannot otherwise be taken. Felonies. You know, murder, rape, kidnapping. Those are supposed to be capital crimes. That's when they can start breaking open doors. Not for these bills of attainder out here. Oh, a failure to identify. You're resisting and obstructing. You're under arrest for resisting. Is that a felony? Is that a breach of the peace? You can't make an arrest. And we have no duty to answer any questions, nor provide any identification to anybody. We have no duty, Hale versus Hinkle. But more specifically, the Fourth and Fifth Amendment. The Fifth Amendment protects us from saying anything. Miranda versus Arizona is a really good read. Aside from the part that says, there shall be no rulemaking or legislation that would abrogate a right. Keep reading, because it talks about the woman who evoked her right to remain silent, and it says, in the case, federal case, Supreme Court of the United States of America, specifically say, at any time during the investigation, that the party just indicates that they don't want to answer any more questions. They are immediately to cease and desist and be done. They cannot continue to ask more questions. Good question, Joe. I love this one. Well, what's the difference between an Article 1 court and an Article 3 court? What are you talking about? There is no difference. Because Article 3 says it's the judiciary. It says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress from time to time may ordain and establish. What that's saying is, okay, we're going to delegate some judicial power here, and it's all vested in the Supreme Court and the inferior. So you can't exceed, you can't alter or change the jurisdiction of the courts. What this is talking about when you're saying Article 1 courts is creating those courts, is because when new states are admitted to the Union, Congress has the authority to create what people call Article 1 courts. No, they are inferior courts to the Supreme Court. They are all federal courts. But what is the jurisdiction of the Supreme Court and the inferior courts? Oh, the judicial power shall extend to all cases in law and equity. In law, not at law. In law is what? Admiralty and maritime jurisdiction. That's the only jurisdiction here. Where does it give any other jurisdiction? Here. There is no other jurisdiction other than admiralty and maritime jurisdiction. Where is it? Can you point to it and grunt? Because it doesn't exist. Who the parties are to the cases. But again, there's no such difference between what people call an Article 1 court. They're all Article 3 courts under admiralty and maritime jurisdiction. Because in law are those that are bound by the Constitution, who are in the military, admiralty. Those who are in commerce, that's in law. At law is at common law. That's the only other jurisdiction. But that's a power and jurisdiction retained by the people. Seventh Amendment. Cannot be otherwise re-examined in any courts of the United States, except pursuant to the rules of the common law. Therefore, our common law courts are not courts of the United States. Does that make sense, people? And our common law courts are supposed to be in every city or town where we have a justice of the peace. Those are the real courts. And then we're supposed to have a district court. And then we're supposed to have the Supreme Court. We're also supposed to have a probate court. And that's it. That's our true Republican form of government. The Supreme Court of a state, the probate court, the district court, and then at a city level, we're supposed to have our justice of the peace courts, our common law courts. And even the district court is a common law court, because that's the only jurisdictions that the state has. Now, to help clarify all that, you're not quite convinced yet. Let's go look at the Judiciary Act of 1789. Boy, this is very enlightening. Even under admiralty and maritime jurisdiction, which is more or less there it is. Military and commerce, right? Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled that the Supreme Court of the United States shall consist of Chief Justice, 5 Associate Justices, and 4 who shall be a quorum. and shall hold annually at the seat of government 2 sessions, when commencing the first. Shall be divided into 13 districts, to be limited is called as follows, blah, 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 blah. All these districts. Yep. And that in the districts that have but one place for holding the district court, so there's what I'm talking about, creating these so-called Article 1 courts. They're still all Article 3 courts. It's the legislature, the Congress, that has the authority to admit new states to the Union, so they have to have the ability to create these federal courts. Which shall be called circuit courts and consist of any 2 justices Supreme Court. So then, see, we got the districts, then we got the circuit courts, and then you have the Supreme Court. That's it. District, circuit, Supreme. Yeah, see right here, it even talks about beginning of the first of the circuit courts shall have power to hold special sessions for the trial of criminal causes at any other time at their discretion or discretion of the Supreme Court. Where? Right here. Be it further enacted that the district courts shall have exclusively of the courts of the several states cognizance of all crimes and offenses shall be cognizant of the authority of the United States committed within their respective districts or upon the high seas, where no other punishment than whipping, not exceeding 30 stripes, a fine not exceeding $100, or a term of imprisonment not exceeding 6 months, is to be inflicted, and shall also have exclusive original cognizance of all civil causes of admiralty and maritime jurisdiction. What? Including all seizures under laws of impost, navigation, or trade in the United States, where the seizures are made on waters which are navigable from the sea by vessels of 10 or more tons burthen within their respective districts, as well as upon the high seas. Saving to suitors, in all cases, the right of a common law remedy, where the common law is competent to give it. So even under admiralty and maritime jurisdiction, which is a place, we still go by the common law, even in the federal courts. And then it even says, and shall also have cognizance, concurrent as last mentioned, of all suits at common law where the United States sue, and the matter disputes amounts exclusive cost to the sum and value of $100. And shall also have jurisdiction inclusive of the courts of the several states of all suits against consuls or vice consuls, except for offenses above the description aforesaid. Now, and the trial of issues in fact in the district courts, and all causes except civil causes of admiralty and maritime jurisdiction shall be by jury. Imagine that. But this is in line with Article 3. But again, on the high seas, that's maritime. On the navigable waters, navigable. From the sea by vessels of 10 or more tons burthen. So when they try to say, oh, well, this is navigable water, are you talking about a 10-ton ship vessel can come here from the sea? Highly doubt it. Like to see that happen, because it ain't happening. So, like it says in the Constitution, it's still, if it's going to be criminal, you still have the right to a trial by a jury, except in civil cases of admiralty and maritime jurisdiction. Civil, not criminal. And see, that's the thing. When we're talking about the right to travel, people talk about the right to travel. What is it? It's commerce. Traffic is commerce, or commerce undoubtedly is traffic, to quote Joseph's story, pursuant to Article 3, or probably Article 1, Section 8, Clause 3, the Commerce Clause. He specifically states that we have to look into what the heck it even means. And he says commerce undoubtedly is traffic. And traffic is the transportation of passengers or property for any fair fee in what? Foreign or interstate commerce. That's that. And it has to be in a federal court, because commerce is delegated, the subject matter of commerce is in fact delegated to Congress and right in the Constitution. So the states aren't even supposed to be doing anything with traffic, commerce. 10th Amendment. Right? Isn't that what it says? 10th Amendment, right? The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states directly or to the people. Well, Article 1, Section 8, Clause 3, to regulate commerce with foreign nations and among the several states and with the Indian tribes. So that power is delegated. Therefore, the states are prohibited. And because this would be a suit in law, because you're in commerce and not at common law, so that's where we're supposed to be according to the Constitution, the supreme law of the land, and the Judiciary Act of 1789. So pay attention. There's the law as it is written. I'm not making it up. Everybody can read this and comprehend it. Well, I should say everybody, I shouldn't say that everybody can read it and comprehend it. But it is there in writing, the letter of the law, in the clear and plain language of the Constitution. That's what it says as it is written. That Congress has the power to regulate commerce, and the Judiciary Act of 1789 says for admiralty and maritime jurisdiction, commerce, that has to be in a federal court. And it's supposed to be civil. But even where it's still civil, we still have the right to the common law. Because the common law is the fundamental law. That makes sense, folks? And Joe out here on YouTube, I could care less about that Jolly Roger gold fringed flag. We're talking about real law, the letter of law. We need to learn this. Because knowledge is power. And this is how we put government back into the tiny little box that it belongs in. And it can only be done by the people. We're the ones with all the power. So how are we going to put government, quote unquote government, back in the tiny little box that it belongs in if we don't know how it's supposed to be? And then we got to come together. We have to consult for our common good. And we need to do some grand jury presentments now, don't we? We have that power. That right and power is retained by the people. Not American state nationals. It's by the people. So, here we are. Reading means reading, right? You know, Ram Red Bud, right? How long we've said that? Reading means reading. You literally have to read this stuff to gain the knowledge. And once you gain this knowledge, then you can start wielding that sword of knowledge to cut them down. And that's when we're going to start getting justice. Is when the people wise up, gain this knowledge, and learn how to effectively wield the law. Actually, a lawyer. One who is knowledgeable on the law. One who speaks the law is a law sayer. Good question, Wendy. Where did all this American state, national, etc. originate from? Anna von Reitz, who has a blood oath bond to the Pope and the Vatican. I have the proof of this. She even posted it on her own frickin' website. She is the one that concocted all this crap about American state national. And again, if you do the research, one, in the United States Code, where they're going from is code, right? Roman civil law. We'll get to that. But the fact is, it's coming from the code as national. Did not come into being in the United States Code until 1887. And then you go to etymology for the word national. As a noun, did not come into existence, as a political status, as a noun until 1887. So what the hell are we supposed to be? The people. All political power is inherent in the people. The right of the people to be secure. We the people. The people. The right of the people to keep and bear arms shall not be infringed. It's the people. Or the inhabitants. Or the citizens. The citizens are the public servants, the elected officials. Plain and simple. The definitions of those are found in the Law of Nations. Book 1, Chapter 19, subsection 212 and 213. It's in the Arms Confederation. It's in the Constitution. In fact, it's Article 1, Section 8, Clause 10. Right there. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. Well, that means the law of nations is a body of law. Isn't that what that says right there? And offenses against the law of nations. Well, I'll be darned. I think the supreme law of the land dictates that the law of nations is a body of law that Congress has to abide by and can make offenses against that to define and punish piracies and felonies against the law of nations. So many people ask, well, what makes you think the law of nations? How does the law of nations? It's right there in the Constitution. And the fact that the law of nations is part of the common law, as opposed to Roman civil law, the code. Munson 58, good to see you. Oh boy. Yeah. Yeah, the bikers in Sturgis, they're headed to Dearborn. Bikers and pork barbecue. Yeah, Diesel D's. That Judiciary Act of 1789 is made by Congress pursuant to Article 1, Section 8, Article 3, Admiralty Maritime. And notice that it talks about ambassadors and all that stuff. Okay? All that verbiage is pulled straight from the Constitution. See? And shall also have jurisdiction exclusively of the courts of the several states of all suits against consuls or vice-consuls, except for offenses above the description aforesaid. So, this goes back to Article 4, Section 1, full faith and credit shall be given to each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. The citizen of each state shall be entitled to all privileges and immunities of the citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Article 4, Section 3. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned, as well as of the Congress. Now, the second clause of Section 3 is, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. No, Sprinkle 777 out here on YouTube. No. ICE is basically military cleaning up people that are here unlawfully, illegally. It is a felony to enter the United States of America without permission. That's a felony. It's an arrestable offense without a warrant. Don't need a warrant to make an arrest for a felony. But a lot of the ICE ones, they're not a citizen of the United States. They're illegal aliens. They're here unlawfully. And unless there was a warrant, let me clarify for you what ICE really is. Because Second Amendment specifically states that we are to have a well-regulated militia, being necessary for the security of a free state. Think about this for a second. All federal, whatever you want to call it, is all the well-regulated militia. It's all military. Trump took office and the military took over. This is, in fact, a military operation. Whether you like it or not is irrelevant. Whether you are familiar with the law or not is irrelevant. Because let's read the very next section, Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government. Do we have a republican form of government right now? No. And shall protect each of them against invasion. And on application of the legislature or of the executive, when the legislature cannot be convened against domestic violence. Internal insurrection, an attempt to overthrow the Constitution and war against the people. What do you think's going on? You think the law's being followed by the executive, which is the commander-in-chief? Not president, commander-in-chief, military. And as a Marine Corps veteran, I'm telling you right now, that's what's going on. Well, sprinkle 777 out there. Get it squared away. But unless he's passed the immigration test and actually gained his citizenship, he is not an American citizen. Period. No, I am not wrong on the militia, cocky Hemi. Because that's what it says as it is written. I can't be wrong. Let's read it together. A well-regulated militia, being necessary to the security of a free state. And I just read to you Article 4, Section 4. You're citing code, dude. I'm citing law. Do you know the difference? No, you clearly don't. And that's the problem. I don't care what Title 10 of the United States Code says, because code is Roman civil law. That's a foreign jurisdiction. It is foreign to our Constitution, unacknowledged by our law. It's in the Declaration of Independence, you know? Remember the Declaration of Independence? Now, I'll tell you about Title 10 and the militia stuff. There are 3 types of militia. There's the federal organized militia. That's the well-regulated militia, which is the federal military. Then there's supposed to be a state-level organized, regulated militia, which is still regulated by Congress. And then there's the unregulated or unorganized portion of the militia, which is composed of the body of the people themselves. And that's the part of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. We, the people, have every right to peaceably assemble and take up arms if need be. That's the law. Tammy, I'm right there with you. If the United States turns into a Muslim country, well, where'd it go? I am not wearing those things over my head whatsoever. I hear you. It will be over my dead body for sure. Yep. And yep, absolutely. We the people are the militia. In fact, let's go back to the Northwest Ordinance. So we understand who the people really are. Let's see. The governor, for the time being, shall be commander-in-chief of the militia, appoint and commission all officers in the same below the rank of general officers. All general officers shall be appointed and commissioned by Congress. Now, pay attention here, folks. So soon as there shall be 5,000 free male inhabitants of full age in the district, upon giving proof thereof to the governor, they shall receive authority, with time and place, to elect a representative from their counties or townships to represent them in the General Assembly. will all be damned. It's the free male inhabitants that give notice that become the militia, that also have the right to be elected. Because like it says, provided that for every 500 free male inhabitants, there shall be one representative. And so on progressively with the number of free male inhabitants, shall the right of representation increase until the number of representatives shall amount to 25. And for further clarification, we'll go back to the Virginia Constitution. Oh, no, it's going to be in the Virginia Declaration of Rights, June 12, 1776. That a well-regulated militia, composed of the body of the people, trained to arms as the proper, natural, and safe defense of a free state, will all be damned. That sure sounds like the Second Amendment shortened up now, doesn't it? That a well-regulated militia for the defense, security of free state. Doesn't that sound like the Second Amendment? We'll all be damned. There it is right there, spelled out. So, history of law right here, folks. And this is the very first Declaration of Rights, June 12, 1776. Many people are not aware that these are the real founding documents of this nation called America. And it is the Lee's Resolution, June 3rd, 1776. Then we have the Virginia Declaration of Rights, June 12th, 1776. Then we have the Virginia Constitution, June 29th, 1776. And then we have the Declaration of Independence, July 4th, 1776. All four of those documents go together. Those are our original founding documents for this nation called America. Because so many people do not understand and comprehend the history of Virginia. Virginia was first. The territory of Virginia encompassed a total of 7 of the states. 7 of the states were created out of the territory of Virginia. So we have the first charter of Virginia, 1606, the second charter of Virginia, 1609, and the third charter of Virginia, 1611, 1612. And then we have the Mayflower Compact, which it's not as this big thing like everybody thinks it is. All it says is, hey, we're coming across for, we're fleeing Great Britain, England, for religious purposes to set up over here in America, right? And that's about it. It's three short sentences, paragraphs. 3 sentences. But the real document is the Ordinance of Virginia of 1621. That is the first government separate from the crown, from Great Britain, from England, from the crown, from the king. And that is where we get the General Assembly of the people, started in 1620, 1621, the Ordinance of Virginia. right? Then there's the Articles of Confederation, because we are a Confederate Republic. You know, in order to form a more perfect union, the preamble, that means that we already had a perfect union, right? We the people of the United States, in order to form a what? A more perfect union. So we already had a perfect union, which is a Confederate Republic. Which, if you read Montesquieu in his Spirit of Laws and The Law of Nations by Emer D. Vattel, although Montesquieu breaks it down a little bit better, but it's still in the Law of Nations breaking it down, the different types of a republic, which is what? A democracy, an aristocracy, and a confederacy. All three of those CCCs are a Republican form of government. Our Republican form of government is in fact a confederacy. It's all throughout the Federalist Papers, and it's right here in the Articles of Confederation as it is written. I just showed you the preamble to the Constitution in order to form a more perfect union. Because what does it say? The style of this confederacy. Doesn't say democracy, and it doesn't say aristocracy. It says confederacy shall be the United States of America. That's a capital T with a capital U and a capital S and a capital A. That is our nation, the United States of America. All of the states are countries within the nation called America. And that would be Law of Nations, Book 1, Chapter 19, Section 211. That a nation is composed of all of the countries. That's why we have independent flags. We all have our own flags. That's a symbolism for a country or nation state, but we are one nation. We have united. America is the nation. Just like it says, the said states hereby severally enter into a firm league of friendship with each other. Well, what is a confederacy? It's a union. What's a union? A union is a league of friendship. Well, what's a league of friendship? A confederacy. Now, pay attention to this one. The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all the privilege and immunities of free citizens in the several states. Whoa, wait a minute. So we have free inhabitants and we have free citizens. Huh. Imagine that, folks. Correct, Amundsen, 58. Not the United States. It's the United States of America. It is all of the states who have joined in this perpetual mutual friendship, a league of friendship, the Union, Confederacy. The U.S. Inc. is the United States. United States Incorporated, not the United States of America. So, hopefully you all learned something, because knowledge is power. And without this knowledge, we have no power. All right, so hope you enjoyed the show tonight. You learned something good. Well, Mark, you know, in the Constitution itself, it says the Constitution for the United States of America. And that's in the preamble. It says the Constitution for the United States of America. But then in the header part, they say the Constitution of the United States of America, or the Constitution of the United States. Yeah, I'm with you on the Statute of Liberty as well. The Statute of Lucifer. I called that the Trojan horse. The Statute of Liberty is a Trojan horse. It's a scam. All right, folks, if you want to help support over here, links in the description below. And KirksLawCorner.com, you can go there to get my social media stuff, access to Patreon. You can donate through Patreon if you want. Tier 1, Tier 2, you can do through the Buy Me a Coffee. That's the better way to go, is through Buy Me a Coffee. If you want to get in on Wednesday Night Workshop, that's Tier 3. If you're looking for one-on-one time with me on your personal whatever questions you have, any education you're looking for, help with your cases, whatever, that's Tier 4. That's one-on-one time with me. Okay? And that's all done through Patreon. Alright? Other than that, have a wonderful night. God bless everybody. Thank you all for being here. And like, follow, and share, folks. Let's get the message out. Let's get this knowledge out there. Everybody needs to learn this stuff. Ain't nobody else teaching this stuff. I can tell you that right now. Look at the people that are here that have been here for a while. Nobody else is teaching this stuff. That's why I keep going, because nobody else is doing it. So, God bless everybody. God bless America. God bless the world. Peace be to everybody, right? Much love. Good night, everybody. We'll see you Wednesday night for those in Wednesday Night Workshop.